I must bring on record that many efforts have been made to improve the police. I would restrain to use the word reform because I think it is quite bombastic. It gives a sort of false perception or an impression as if things uh, will be radically changed. So I would like to use the word um, um, improvements. So many police reforms committee reports came on record, and most of them were led by the state itself. There is one important big report of 1985, and then the journey started from 1985 to 2002, and we saw the Police Order 2002, which was a very progressive law. It not only recommended torture as an offense, it criminalized offense for the first time in Pakistan by including Article 155 in the Police Order 2002. So, in fact, it was police leadership who brought in the concept of criminalizing torture by police, because police leadership thinks that it is a very, very serious issue. The policing has to be human-centric, human rights-centric, and it has to serve the citizens and public at large. In order to do that, we have to move towards scientific methods of investigation and to the best criminal justice practices around the world. The supply side of criminal cases is a very big issue in Pakistan. You have heard the citizens complaining about lack of registration of their important cases. To address that, the police officers, the leadership is very, very generous towards registration of FIRs. While doing that, the registration has surged in a big way. We have already touched 1.4 million cases, which was 3.5 lakh just in 2019. So the numbers have increased this big volume. The qualitative side of the investigation then becomes the problem. I must congratulate the citizens of this country that at least we are the most progressive in this region. India still does not have a dedicated law on this subject. So we are the most progressive so far as the legislation is concerned. Now the next question is about its implementation. The issue is that its design is quite complicated, because it, instead of introducing independent investigation within the police organization itself, it is uh, giving that part to an outside agency, which in this case is a federal agency. So God forbid if there is a cross purpose sort of political government, uh, there would be issues with how to use this law. So this law will face its challenges. I think its architecture needs to be simplified. We need to have dedicated units within the police to look at the torture, because they are the most equipped to do that. This was quite ambitious to ask for FIA, which is an organization that deals with white collar crime, to deal with police torture. So there are issues with its architecture. In absence of a mandatory referral regime, many cases are left unattended. So I think we need to look at this from a different perspective. The gap of supply of cases through referral, that I think is a very serious issue. I just referred to you that we need to look that in context of crime scene investigation. You cannot wait for bureaucratic processes, because no crime scene will wait for that approval process to come and to collect the evidence. So evidence collection is to be done promptly and most evidently. So I think that gap must be addressed in order to make the law more robust and more effective. When you expand the definitions of torture, you bring in all sorts of cases, you attract all sorts of cases, and this gives an opportunity to delinquent police officers to forum shop their own IOs in these cases. So we need to look at it quite differently. What we do in legislation in Pakistan, we always start very ambitiously. We have to take an incremental approach. We have to start with narrow, trite definitions so that the scope of investigation is quite clear. There is certainty in law. All sorts of cases are being sent there because of the expansive definitions of torture, which are more expansive than what was the requirement of international law. This mental suffering aspect is again a very expansive way of dealing with this definition. I understand this is very important, but I think we need to do incrementally, because you cannot penalize every bit of it. There are different ways of punishing police officers. One is to criminalize the matter, the other one is to deal with that departmentally. So in departmental action, we do about 27,000 departmental orders every year, and they go to PST. So there is a full chain of cases that take place. So I think we need to look at that in a more different way, given the fact that our society is also getting more and more violent and extremist. So, and it is an adage that police is just a reflection of your society. So we need to look at it in a different way. Torture is an offense against the state. It is not an offense against the person. Unfortunately, by providing compounding provisions, you have taken away the teeth of the law. It has become more ineffective because of this. I know the original draft did not provide that the custodial rape should be compounded, but at the moment it is in that form. So I think we need not to have this compounding aspect in it, because no compounding should be allowed. Police officers have double responsibility. They are not any standard institution. They are duty bound to protect the human rights of people. This is their duty number one. So if they fail in that, they are to be taken, and if you expect them to do that, then they are to be their standard should be up. They are working against a higher standard, and unless we introduce these type of standards, no police organization can be torture free. And we look forward to have a torture free sort of police organization, especially in Punjab. So I think there is a good case of revisiting these provisions. These are not against any person. Had that person been so powerful, in the first place, he would have never been subjected to torture. So state comes there and state stands there and state is owning the case. When state is owning the case, then there should be no provision of compromise in torture cases. This is not qisas and diyat. This is very clearly a state-based legislation emanating out of our international legal obligations. Collection of evidence is the subject in itself. We work on it a lot. The conventional approach in Pakistan was that all the cases were convicted on the basis of direct evidence. But that approach is changing with the passage of time. Now circumstantial evidence, we have seen convictions on the basis of circumstantial evidence. Even this year in 2025, in Zahir Shah case, they invoked the theory of silent witness and they said that CCTV evidence is sufficient to sufficient to base conviction on it. So things are changing and things are improving. We are slowly but surely we are moving towards this direction, and we have started training our police officers on audio-video collection of audio-video evidence as well. Now almost in every cases we track back the CCTV trail, the audio-video trail, and then we bring that on the record of the case. So things are changing, and the police officers are using forensic agency facilities as well as audio video facilities which are available and which have got their legal cover by the amendments in Article 164 of the Kamran Adil order in 2017. So things are really changing, but yet we have to do a lot of work because the perception is not what we want it to be. Important thing is perception. No matter what you do, unless the perception changes, everything stays the same. Police accountability is on the right path, but I think we need to increase we need to put in more robust independent systems, which we are already doing, but I think we need to structure it more. Number one. Number two, there is one big issue, I call it elephant in the room, and that is ownership of criminal laws in Pakistan. Very few people would own the criminal laws, especially crimes against women and children. You have to own these cases. You have to go after them. You have to make sure that the right amount of evidence is collected. For that, we need to introduce structural improvements within our own system. Like we have to set the standards within police, and then we should monitor those standards very stringently. So if that is done, things will start improving and you'll see a visible change in attitudes of the people. Work is being done. IT is a big new player in the criminal justice system in form of Punjab Safe City Authority. It is now upscaled almost all over Punjab. Almost all big cities now have Punjab Safe City Authority setups. Now we need to integrate it into the criminal justice system, and it has to be given the evidentiary value. And I think things will start improving by that. So this structural welcoming of IT-based interventions within the criminal justice system will improve the things a lot.